Hi, this is Roxann Smithers with Smithers and Ume-Nwagbo, and this is a note from my Legalpad. Today we're going to talk about indemnification, or indemnifying another party. You'll often see this provision in contract agreements. Individuals very often don't pay attention and they do not understand what they are agreeing to when they agree to indemnify a party. They often don't understand the significance of it until a claim is brought and they are being required to do just that. So we're going to talk a little bit about what is indemnification, talk about an example, go over the effect of an indemnification provision, and then we're going to talk about a couple different ways that you can modify that indemnification provision to accurately and fairly distribute the risk and liability associated with a contractual agreement. So again, we are going to be talking about indemnification. Indemnification generally means taking responsibility for claims, damages, or losses that might be incurred by another party that are related to your actions or your relationship to that party. And we'll give you an example. Standard indemnification language that you may find in agreement may say, web developer agrees to indemnify, defend, and hold harmless customer for any claims, damages, or losses that are brought against the customer as a result of web developers' performance of this agreement. Now, here's the effect of that indemnification provision. Say, for instance, as that web developer, you are providing photographs, other images, and content for a website that you're developing for a customer. Now, say that an individual comes forward, photographer, and says that they have a copyright on a photograph that you utilize on that website. And they bring a claim for copyright infringement against your customer. Your customer will then look to its contract with the web developer and say, hey, web developer, you are required to indemnify and defend me against claims based upon your performance. You put on the website a photograph that may infringe on the photographer's copyright. The photographer has sued me. I need you to defend me. In that instance, the web developer will be required under the terms of the contract to step into the shoes in some format of its customer. That may simply mean paying for the defense, meaning during the litigation or at some point when the litigation is over, reimbursing the customer for the attorney's fees and costs that they've incurred, paying a judgment if there is found to be actual copyright infringement. That may involve engaging an attorney to defend the customer in the litigation. That may involve actually stepping into the customer's shoes and becoming a party to that litigation. So there are a couple different ways that you can either expand or contract the indemnification rights in any agreement. One way that you can do that is by adding additional individuals that will be either covered by the indemnification right or bound by the indemnification obligation. You'll often see after the name web developer any employees, agents, officers, assigned, successors, heirs, agents of the web developer agree to defend, indemnify, and hold harmless the customer, any heirs, officers, owners, representatives, successors of the customer. So by adding those different individuals that may be related to the two main parties, the web developer and the customer, to that indemnity provision, you're adding individuals who may be responsible as well as individuals who may be able to have a right under that indemnity provision. Next, you can look at the circumstances under which the indemnity provision will apply. You may find broad indemnity provisions that cover any actions or any performance by the web developer under the agreement. That makes it broad. You can limit that indemnity obligation by saying, to the extent the web developer has acted negligently or purposefully negligent or is actually in breach of the contract. Those are all conditions that can limit when the indemnity provision applies. Another way that you can limit that indemnity provision is by putting a cap on the dollar amount that the web developer may have to incur to indemnify. You can limit it to X times the amount of the contract. You can limit it to the amount that the web developer has insurance coverage, or you can limit it to any other amount that the parties agree to. Finally, you can contract the indemnification provision by limiting the types of claims that will apply. You can say that the web developer is only liable for third-party claims that are brought against the customer. In this instance, the copyright developer. You can limit it to actual losses or injuries that the customer incurs. So only if they lose on that lawsuit or lose on that claim, maybe the indemnification goes into effect. You can limit it to specific types of injuries, other specific types of claims, whether they are for breach, whether they are for violation of intellectual property, whether they are limited to personal injury. So those are some ways that you can constrict or expand an indemnification obligation. And obviously, your motivation to constrict or expand the indemnification obligation depends on whether you're the party providing the indemnity or you're the party receiving the indemnity. Final thing to think about is that one of the best ways to make sure that an indemnity provision is fair and reasonable is to make it mutual. Very often, drafters of a contract will obviously draft in their favor and provide for a one-sided indemnification that only benefits themselves. Once you require that indemnification provision is mutual, meaning each party is going to agree to indemnify the other party under certain circumstances, you'll be amazed at how reasonable people become with regards to ways in which they can limit and constrict that indemnification provision. So in sum, you want to make sure that you are aware of your indemnification rights as well as your indemnification obligations in your contracts. Do not be afraid to negotiate those terms to either expand or constrict the obligation or the rights, depending on who you are in the situation. And as always, mutuality usually inspires people to be fair and reasonable. And for more information from the attorneys with Smithers and Ume-Nwagbo, you can go to our website at stulawgroup.com. You can find us on Facebook, LinkedIn, as well as Instagram. Please be sure to like this video and to subscribe so that you can get the latest notes from our Legalpad.